Hello, my name is Samantha Jago and I'm a family law partner with DMH Stallard. I'm joined today by my colleague Rachel Osgood, who is also a family law partner here at DMH Stallard. Today we are going to be talking about inheritance and how this will often find its way into financial negotiations upon divorce when you're resolving matrimonial matters. So Rachel, the issue of inheritance often arises when we're dealing with family law matters, and often people are concerned about any future inheritance that they might be receiving, an inheritance they have received and has already been spent by the family, or inheritance planning. And what are the sort of issues do you find that come up?
Well, I think it's important, first of all, to say that inheritance can often be a really emotional subject for people on divorce. It might involve a dying parent's last wish, and perhaps one of the parties wants to make sure that that parent's last wish is carried through. For example, I dealt with a case where the wife went to extraordinary lengths to try and cover up her inheritance from her very much loved mother, who didn't want her son-in-law to get his hands on a penny of it. So she lied and she tried to cover up the inheritance, and when the inheritance was found, she lied again. And when she was asked about it in the witness box, she broke down and cried.
And was this inheritance that had been received during the course of the proceedings or prior to her separation? When had that inheritance come into play?
It came into play after the parties had separated.
Right.
So during the separation, the wife's mother was very ill, so they knew it was coming, and then she died and left her estate to her two children, but the wife's share was on trust, which on the face of it put it beyond the husband's reach. But she'd written a letter of wishes to go alongside the trust, which really meant that her true intentions were that the daughter should benefit. So the court was able to take it into account. But the end result was that the husband didn't get his hands on a penny of it. He never would have. But what it did mean is that his costs were vastly inflated because he'd had to go to such lengths to find the inheritance, and she was saddled with a £40,000 cost bill for trying to cover it up, when actually the way it turned out was if she'd listened to good advice from the start, she would have known that he wouldn't have got his hands on it anyway.
Okay, so if somebody does get an inheritance during the course of proceedings, what should they do with it?
Well, during a divorce, both parties are under a duty to provide full and frank disclosure of their financial affairs. So that would include all the assets, which would include an inheritance if it's been received. And my advice to people in those situations, regardless of how you feel about the inheritance and whether your spouse should have any claim on it, that's completely a separate question. Disclose it, first of all, because that's what you have to do. And take advice about the relevance of the inheritance in the divorce. It may not be relevant at all.
Okay, so a lot of people would be worried that if they do get inheritance during the proceedings or negotiations, that their spouse will get a share of it. Is that automatically the case? Does it go into the pot for distribution, or is there a chance of ring fencing it and keeping it out of the negotiations?
There's really two situations in which an inheritance might be shared on divorce. The first is if it's been matrimonialised, in which case it will be subject to a presumption that it will be shared between the parties. The second is if there's not enough money in the matrimonial pot to cover both parties' needs, then it may be necessary to share the inherited assets.
Okay, so you've used two terms there, matrimonialised and needs. Could you explain both of those terms to us?
Yeah, so when we talk about matrimonialised assets, in that context, there's two types of assets on divorce. There's matrimonial and non-matrimonial. Matrimonial assets are going to be subject to a presumption of equal sharing,
Okay.
subject to need. Non-matrimonial assets aren't subject to that presumption. And in fact, if there's enough money in the matrimonial pot to cover both parties' needs, then any non-matrimonial assets will stay with the owning party.
Okay, so needs means what? Housing needs, income needs? What does that mean?
Yeah, so generally speaking, everyone has the same needs. You need somewhere to live, you need an income, and you need provision in retirement. But what one person needs can be vastly different to what another person needs. So if your family is used to living in a country mansion with staff at your disposal, then a 3-bed semi on an estate is not going to meet your needs. So needs is all about context, all about standard of living during the marriage.
Okay, so if somebody gets an inheritance during the marriage, they should disclose it. And further, there is a good chance it will be counted out if the parties' needs can be met from the matrimonial assets. Is that a fair summary?
So long as it's remained non-matrimonial, that's correct.
Okay, so I'm going to give you an example where perhaps it might have become a matrimonial asset. So for example, I get an inheritance 10 years before I separate. I pay down the mortgage on the family home. Can I get that back? Or has that then gone into the pot and I can't get it back?
I think you'll find that inheritance will have been completely matrimonialised. It's been mingled, and actually not just mingled, but mingled into the family home. And the family home itself has a special place in divorce financial remedies, in that is very strongly subject to a presumption of equal sharing. So yeah, once you've popped your inheritance into the matrimonial home, it's almost certainly going to be a matrimonial asset, and therefore subject to that presumption of equal sharing that I've talked about.
What about if, again, same scenario, but I've actually put my inheritance into a bank account in my sole name, and I've just left it there as a nest egg just to grow and get some interest and maybe dip into it when I need it? Would that also have to be shared, or would I have a chance of being able to say, actually, that should be kept out of the negotiations?
One of the ways in which a non-matrimonial asset might become matrimonialised is through being mingled and incorporated, perhaps, into the matrimonial assets. So one of the ways that you might consider keeping it separate is to make sure, if it's in money in a bank account, that you keep that account in your sole name, that you don't share it with your spouse, and that you don't use the money for family purposes. So it might be okay for you to withdraw chunks for your own private use, maybe, but certainly not to put into the matrimonial home, to pay for improvements or to buy any property, and not to use perhaps the interest from it for family benefit either. Keep it entirely separate, and there's a good chance that it will remain non-matrimonial.
Okay. Another question that comes up a lot is when people are preparing their financial disclosure, and we are often told that the other party, the other spouse, has really good inheritance prospects. So it's not actually inheritance received, but they might go on to receive. Will that be taken into account?
Generally speaking, no. If the person from whom they're hoping to inherit is still alive at the time of the divorce, then it's generally thought that any inheritance is too remote really to be taken into consideration, because that person might change their will at any time up to death, might leave the lot to the cat's home. There's no guarantee that either of the parties will actually inherit. So long as the party that person stays alive until the divorce is concluded, it generally won't be taken into account.
And there might be some parents watching this who want to give gifts to their children. They're thinking, well, it's inheritance tax planning. I want to part with money now so that I can reduce any burden against my estate when I pass away. Can they protect it in any way?
So those parents should always take their own independent legal advice, first of all. So they'll be advised separately about how to protect those gifts. Maybe it's better to make them as loans. But they might also want to talk to their adult children about perhaps entering into a nuptial agreement with the other spouse, so that so a nuptial agreement can ring fence assets, gifts like that come from outside, so that on divorce they're not shared.
Okay, what is a nuptial agreement?
So we often talk about prenups. It's an agreement. They can be done post marriage as well. So it's an agreement between the two parties to a marriage that if they ever get divorced, the assets will be shared in a particular way. So it usually works to limit one party's financial claims on divorce. Okay.
And with the nuptial agreement, does it have to deal with all of the assets and all the income, or could you just be quite discreet and just deal with the issue of inheritance?
They can be as wide-ranging or as narrow as the parties themselves agree. So, yeah, very often people will come and ask about a nuptial agreement where one party expects to receive, or maybe even both parties expect to receive, significant inheritances in the future, and they want to just keep those inheritances out of the divorce settlement, regardless of the circumstances on divorce.
Have you had any cases where inheritance has in fact played quite a big part in the negotiations? Have you any had cases like that?
Yeah, I mean, it does crop up, not infrequently. So there's the case that I've talked about earlier with the wife who just didn't take the advice that I'm sure her solicitors gave, that she didn't need to cover up the inheritance. The husband wouldn't have got his hands on it anyway. There was also a case a few years ago where the parties were, not in the first flush of youth. The husband's parents had already died and he had inherited quite significant sums, which had been thoroughly mingled in the matrimonial assets. So when they came to divorce, those assets were subject to equal sharing, absolutely. That felt really unfair to the husband, because they both knew that when the wife's mother died, she was also wealthy, the wife would inherit further significant sums and the husband wouldn't have any share of that. So it felt unfair, but the law, sadly for that husband, wasn't on his side.
So the central message is get some advice. Don't hide any assets that you receive. Disclose them all. Try to keep them separate. If you get them during the marriage, you'll protect them. But otherwise, disclose them, and potentially, but not always, they might be taken into account.
Always disclose. Always take advice, because you might find that there's nothing to worry about. It's unlikely that the inheritance will be taken into account anyway. Yes, think about keeping it separate. I mean, that can be kind of self-defeating, because you might find that if you're so busy keeping it separate, you don't get the benefit of it. But, if you're in the early stages of marriage, or you think that the marriage might be coming to an end, then you might want to think very carefully about keeping it separate. Nuptial agreements, there's all sorts of things that you can consider to try and protect your position on divorce.
Thank you, Rachel. Should any of the issues we discussed today affect you, or if you require any further information about family law matters, please do not hesitate to contact a member of the family law team here at DMH Stallard.